People versus Vaughn.
Good afternoon. Sam Feldman of Appellate Advocates for Appellant David Vaughn. The trial court in this case excluded important topics of expert testimony on the reliability of eyewitness identifications at a trial where eyewitness identifications were vital to the
When were
prosecution.
these requests made with respect to the trial itself?
So I believe defense counsel first alerted opposing counsel and the trial court that he wanted to call an expert on eyewitness.
That was after the trial court initially made the inquiry of defense counsel as to whether he was going to offer expert testimony, correct?
I believe the initial notification that he intended to offer expert testimony was before trial. It was a week.
That was only on cross-racial at that time,
Yes,
right?
that's right. That's the only topic that was mentioned at that time. But he did say it was a week or 9 days before trial that he wanted to call an
Did
expert.
the court have the ability to consider the timing of the request and the adequacy of what it was that supported him getting it?
Well, there's sort of two responses I'd give to that. The first is that the timing of this request to put on this testimony was not unusual, and it's one that this court has blessed in the past in both People v. McCulloch and People v. Lee.
And the court did, in fact, grant the request for cross-racial identification. Let's go to the second part with respect to those factors. And the court questioned whether he sufficiently laid out support for the fact that he was entitled to get them.
That's true. There was some discussion of that. I mean, I'll say as to the question of whether or not the application was timely, first of all, the court specifically said it wasn't going to deny it as untimely, and it didn't. It denied it on the merits. In general, I think under the criminal...
So let's go to the adequacy of the request.
Sure. So the factors that we're raising on appeal here, these three factors, the effects of stress, weapon
He offered
focus-
more than 3 initially.
He did, yes. There was, I
And
think,
did he
11.
refine them for the court at that point so that the court could make a reasoned decision?
Yeah, the court basically said pretty much from the get-go that for all the factors other than cross-racial identification, it believed they were within the ken of an
What did he
average.
give the court?
Only argument. He didn't give the court case law on that. It's true.
And that's my sort of problem, is that it seems to me, reading the record, the court says, I want you to, you've got to give me some case law support for this.
I think
And counsel says, okay, I'll do that, and then doesn't provide it.
I think what the court said, and this was early on in the discussion, was something like, before I can consider this, give me case law, something like that. And if the court had left it at that, had not considered the request, had not given a decision because it was never given case law, then this issue wouldn't be preserved for this court's review. But the court did, in fact, consider the request at length and did render a decision, did make very clear what that
Did the
decision...
court note that it was a preliminary decision with respect to it?
Did the court know that it was a preliminary?
When the court made a determination, doesn't the record reflect that the court initially characterized it as a preliminary determination?
It did, and then there was further discussion later, and the court made a final decision.
But,
and then-
but didn't, go ahead, sorry.
Did the defendant's counsel after that, what did he do after that preliminary determination?
Just offered further argument during the subsequent
Did he offer
discussion.
case law at that point?
No. And perhaps he should have, but since the court did decide the issue on the merits, I think that the merits of the issue are, ripe for this court's review. And what the court never did was apply the correct test based on existing case law from this
Why
court at
does
the
the
time.
Supreme Court's accurate statement that it has the discretion whether to admit or preclude this testimony warrant reversal?
That statement alone doesn't, but the court never applied the proper test, which is just the same test that applies to any type of expert testimony. This is under this court's decision in People v. McCulloch. That test is, of course, there's the 5 factors, relevance, qualified expert, and so on. And then if
But
it
isn't there
passes-
an argument that the court couldn't tell whether it was or wasn't because the defense didn't sufficiently put forth that which the court needed in order to make that determination?
The defense argued that it was beyond the ken of the average juror. The court concluded otherwise. I think that decision,
So what could one say that's a conclusory argument?
which was the defense counsel's argument was,
Correct.
I wouldn't say it was conclusory. I think defense counsel asserted what he needed to assert, which is that the average juror
With all
just doesn't-
10 of those factors, not 3 like it's been reduced.
The court did address some of them specifically, including at least weapon focus and stress, and argued specifically that those were beyond the ken of the average juror, which is, of course, what this court and other courts have held. and which is also supported by ample empirical evidence as cited in our briefs. But what the court never did was it never looked at the probative value of this evidence and weighed it against any countervailing factors. It never decided that the probative value of this testimony to the jury.
The court was required to do that regardless of the adequacy or inadequacy of that put forth by the defense?
The court was required to do that if this evidence was relevant and passed the other factors of the Frye test.
Doesn't that assume that there was an adequate request before the court? So that the
Yes.
court could ascertain what he wanted, why he wanted it, and what supported it being given to him.
Yes, I mean, I would say as far as what he wanted and why he wanted it, I mean, he did lay out the factors. He made specific arguments as to some of them, including some of these that we're raising on appeal. And as for why he wanted it, I mean, this trial centered on these eyewitness identifications, and that's what the summations were primarily about. That's what the jury was thinking about.
And the record does clearly reflect that the court was aware of that, and the court prompted the defense. Tell me, do you want cross-racial identification? Before he ever even, 2 weeks out, close to trial, defense hadn't asked for anything. But the court was being proactive, so to speak.
In that way it was. I mean, the problem is just that it got it wrong as to these other factors. The court, basically, it said—
And timing has no impact?
Timing, well, there's two different ways timing could have an impact. One is if the court had denied the application as untimely, which it didn't do. And maybe it could have done that. The criminal procedure law—
With respect to exercising the court's discretion.
Yeah, I would say that a trial court, when faced with an application that's at least arguably untimely, if the trial court thinks, given the circumstances—
And not necessarily untimely in the usual sense, but how it's going to impact with respect to the trial going forward, whether you've already picked the jury, whether you've not picked the jury, if it's going to cause other witnesses to be impacted on when they can give their testimony and their potential unavailability.
Yes, so I'd say there's really sort of two related but different timing topics. There's
Correct.
untimeliness and there's trial delay. And I
Correct.
think, yes. So as far as the question of trial delay goes, this is an unusual case because here, although the court did preclude these topics of expert testimony, the expert testified anyway and was cross-examined about his qualifications and his neutrality and his experience in publications. So all of that was essentially a sunk cost. The additional trial time that would have been required to go over these additional topics, which is something that the expert usually tied into cross-racial identification, would have been pretty minimal, especially compared to the—
Would you need a Frye hearing here?
No, and as the trial court recognized, it wouldn't need to hold a Frye hearing if other courts had already held Frye hearings and concluded that these topics—
And which courts had already held that? And not to the cross-racial, put that aside, of course.
This court had in Santiago and Abney for witness confidence, I believe, and then the lower court also had in Abney, and I think some other courts had
Was
as
that
well.
put before the trial court?
No, again, it wasn't something that defense counsel said.
Wasn't that the case law that the trial court was asking for?
The trial court was asking for case law specifically on whether it was beyond the ken, I think.
They did mention Frye, about how this might need a Frye test, or maybe it's already been decided? That wasn't part of the
The court
colloquy?
did say that, but its main conclusion, which it said, would welcome case law on, was that it was within the ken of the average
Isn't
juror.
it the burden of the defendant putting forward this evidence to meet the Frye test standard?
Yes, but again, here, the other courts had already held that this
But
evidence—
again, that wasn't put in front of the judge.
It's true, it would have been better if
And
it
are
had.
you conceding that those areas of law don't require Frye hearings? Those points? Is that your concession here?
I'm sorry, I'm not sure I understand that.
That you don't need a Frye hearing for all 9 of those points?
9? No, I'm just talking about the three topics that we're arguing about in appeal. You don't need a Frye hearing for those because other courts had already held after Frye hearings that those topics
But he
are
didn't just
proper.
limit his application to 3 at the trial.
That's right. But again, I think the test that courts should apply was not the test that this court applied. This court applied the test that this court deprecated in People v. McCullough, the 2-stage threshold test, which first says, is there corroboration? And if the answer at that stage is yes, then nothing else matters. The court can admit or deny the testimony as it pleases. That's not what the law is under McCulloch. That's a position that other state courts have moved away from. And it's one that uniquely disfavors this kind of expert testimony on eyewitness IDs for no reason.
McCullough, I think, seems to say you just applied discretion, right?
I think it refers to, I don't know if the language is exactly this, but basically general evidentiary principles.
Which
So-
involves some level of discretion.
Yes, certainly.
And isn't that what the court did here?
Specifically, the way that the court exercises its discretion by balancing probative value versus countervailing considerations, which isn't what the court did here. But
Yeah, but I don't see the effect of, I think you're arguing the Legrand test, which we said means this in McCulloch. What is different than what we said you had to do in McCulloch that this judge did?
Both the trial court and the appellate division were applying a threshold test, which is exactly what this court said not to do in McCulloch, where, again, first you look at, is there corroboration? If there is corroboration, then you go to the second stage, the Frye test and all that. If there isn't, sorry, I don't know if I said that right. The point is that here the court said there's corroboration, there's nothing further we need to look at. That's not.
I think
He
the
didn't
court
say
said, I've been reading the case law, and the case law says I have the discretion, and he said, I'm applying my discretion, and he made his decision. I don't see where you, show me in the record where he did a two-part test pursuant to Legrand.
The court says, since this is corroborated, and then the court goes on about how strong the video evidence is, the court says, since this is corroborated, it's really totally in my discretion. And then it never refers to any factor that might outweigh the probative value of the testimony. It doesn't even seem to think about the probative value of the testimony, because once it's determined that there's corroboration, there's no further factors that it's looking to there.
Can you address harmless error?
Yeah, certainly. I would say the error is not harmless for sort of similar reasons to why it's an error, which is that the trial was really centered on these eyewitness identifications, the summations centered on the eyewitness identifications, and the prosecutor, in fact, used her summation to assert things that were directly contrary to this expert testimony that was excluded. Specifically, she kept returning to the fact that a gun was held to the faces of the complainant, and she asserted to the jury that when a gun is held to your face, that's a face you're never going to forget, which may be intuitive and may line up with the preconceptions of jurors, but is contradicted by scientific evidence that would have been presented if the expert was allowed to testify on that. So it certainly could have affected the jury's consideration, considering that this case really came down, as the prosecutor admitted, this case came down to the eyewitness identifications. The prosecutor was asking the jury to rely on them. If there's no further questions, I'll reserve the remainder of my time.
Thank you.
Good afternoon, Your Honors. Melissa Owen for the people of the state of New York. This court has not blessed untimely applications. Opposing counsel referred to the cases of Lee and McCulloch.
Yeah, but the judge addressed the merits. The judge did not deny this based on the timeliness or the untimeliness of the application. Why don't you talk about the merits?
Certainly, Your Honor. The judge did not say she was not going to preclude based on untimeliness. I believe opposing counsel misspoke. At Appendix 241, after defendant made his late application for 11 completely new topics, some of which were not relevant to the facts of the case, the ADA got up and objected. And when she did, she said she was going to reserve her objections to the other 11 to some later point and spoke only to the cross-racial identification, the timely application. It was in response to that the judge said, I'm not likely to deny this based on timing. The timing comment was solely related to the cross-racial identification. The judge did appropriately exercise her discretion here. She did not summarily stop thinking about the admissibility of this evidence when she determined that there was sufficient corroboration such that she was not.
But didn't the judge state that it's not, it is within the ken of the jurors for some of the kinds of issues that they wanted to address through the expert, and that seems contrary to what we have said.
Absent
Not
any,
for all of them, not for all, I'm not saying about all of them, but for some of them.
absent any support from defense counsel handing up any case law, she said she believes some
But
of
didn't
them.
the judge say I reviewed the case law?
Pardon me?
Didn't the judge say I reviewed the case law?
She reviewed the case law for some of the topics. We
So
don't
shouldn't
know.
we assume the judge is aware of the case law?
The judge was,
Especially from this court.
Certainly, Your Honor, she did refer to Legrand, she did refer to Boone. It was on the other topics that she wasn't entirely sure of, which is why she twice asked defense counsel for case law, which he did not hand up at any point, though he was given ample opportunity. He
So
made
the
his,
judge denied the motion because the judge didn't know the law?
the judge denied the motion because the request was untimely and because she did
Well,
not.
again, that's not the ground that the judge articulated.
The judge is not required to articulate every specific reason for her ruling. As long as upon review, we look at the record and we can find a rational basis for that decision, the decision can be upheld, and that is the case here. She repeatedly said
And what's
that
the rational basis here? Just that it's untimely?
it's undue delay. When we're performing the probative
If that's
versus-
contrary to the record, that isn't the basis for the finding, what else would make it a reasonable decision?
undue delay alone makes it a
I
reasonable
understand, but
decision.
let's say the record doesn't support that, so I'm asking you to get to something else.
The judge could have found that because there was ample evidence in this case that it would not have been sufficiently probative. Here, when we look at corroboration, it's not just little to no and then everything else afterwards. There's a spectrum. Here, the judge under McCullough is required to look at the case holistically, which he did. We look at the categories. How many witnesses were there? Were there one or were there two? What was the extent of the interaction? Was
But
it
it's hard to see how you can use the evidence that's going to be challenged through this expert testimony as being corroborative. That's the whole point, right? Isn't that the point
the point
of this request? I want to put in this testimony. I want the jurors to fully appreciate some of these weaknesses in eyewitness testimony. Isn't that the point? So
Well-
how can the very testimony that's the subject of the request be corroborative?
Because when there is sufficient indicia of reliability, the judge can appropriately find that the testimony of an expert witness would not have a great likelihood of affecting the result of the
Well,
jury.
what would be the indicia of reliability if the science works in the opposite direction? I mean, the prosecutor got at least one of those wrong.
Well, again, the court was confronted with 11 topics, and here at a remove of 7 years, defense counsel has winnowed them down to the 3 that happened to meet Fry. That's
Right.
not the situation the judge was faced with. What she was faced with
What
was
about the 3, though? I mean, that's what judges do, right?
the
They
judge,
say I'm not going to grant it on this, but I'll grant it on that.
which is what she did, which is why we know she appropriately
Well,
exercised
only on one and
discretion.
begrudgingly so, but let's talk about the 3 on appeal that you say there have been Fry decisions on.
Expert witness testimony provides a lens by which other testimony could be viewed. Because of that, we have to look at what the other testimony and what the other evidence in the case is to see whether or not it would have been sufficiently probative to overcome what, in this case, would have been very specific and record-supported
Well,
undue delay.
other than the complainants who are also the victims, who are also the eyewitnesses, other than the witnesses, what else was the evidence against the defendant?
When we're looking at the reliability of the evidence, it's not just are there victims and did they identify him? We have to look at the quality of the interaction that they had. Was it a few
No,
seconds? Was it longer?
I fully understand your point, it's well taken. I'm asking, in addition to the witnesses, what was the other evidence
There
that
was
the
a video-
judge considered?
There was a video of the entire incident.
Okay.
The defendant showed his face on camera for 30 seconds. You saw his full face, you saw his profile, you saw his height, you saw his gait, you saw his weight, you saw what he was wearing. The jury was able to view that and then look at the arrest photograph of defendant, where he was also wearing a brown hooded sweatshirt. They were then able to compare that with a photograph of defendant taken 4 months before the arrest, where he was wearing a brown hooded sweatshirt. And because of that, because we're not just at the state of eking over the line of little to no, we have more than adequate, sufficient corroboration here. And the evidence, when we're looking at the reliability, also counsels towards preclusion of these other 11 late requested topics. This interaction was inside a well-lit office. It was not outside. It was not in the dark. It was 30 seconds with 90 seconds of defendant, or the robber who was later identified as defendant, being on camera. And after that, we have the 2 victims following defendant for 3 minutes while they're making contemporaneous descriptions over the phone to 911. We're looking at a case where they're in an office, they're arm's length away. The victims had adequate opportunity to view the defendant, and the judge hearing all that and working behind the 8 ball, as she said repeatedly during this case, she found that she would admit the evidence on cross-racial identification because that was something that had already been brought up during the trial. It was something that was opened on. It was something that was part of the cross-examination of the complainants. And here, when we're talking about, I believe we refer to it as the sunk cost phenomenon, adding 11 topics is not a small cost, especially here, whereas the judge said she was already beyond the time that she told the jurors they would sit for. She had already lost an alternate. The ADA said, depending on the scope of the expert testimony that was going to be admitted, she may very well need a rebuttal. We're butting up against the very real courtroom issue of scheduling here. It is a pillar of what can be found to be prejudicial in a case like this, which is why the court appropriately exercised her
And
discretion.
why does the court get to the merits?
Pardon me?
Why does the court get to the merits? Seems like a fair argument you're making for saying it causes too much trial delay. You're late, sorry.
I'm sorry, did you say, why did the court get?
Yeah, why did the court get to the merits?
Possible she was thinking out loud. She was trying to explain what she was doing. She was suddenly confronted with 11 topics and without a list, without case law, without any support from anyone, and saying, I don't think this would be helpful, but please convince me. Tell me, give me some case law. Show me how this would be helpful. She said, if you'd brought this up earlier, things could have been different, but that's not what happened.
Well,
What
she
happened-
says there's corroboration for the identification through the clothing of the defendant as well as a videotape. So isn't that a ruling on the merits, or you think not?
I think that's her determining that she's not constrained to admit the testimony under Legrand, but she does have to proceed into what McCullough counseled as a more holistic view of the case.
And where is
enumerating-
she doing that?
Pardon me?
Where is she doing that? You said she has to proceed as McCullough instructs. Where is she doing that? In this sentence or someplace else?
She's doing it when she talks about the undue delay, because when we're looking at the probity of the evidence, we balance that against prejudice, and something that could be prejudicial and is in this instance under Purdue.
So her
is
references to delay, and there are certainly some, you're right. You think that that is where she's doing the balancing? You said she's got a balance, right? The probative value and the prejudice. I think that's what you just said.
That's right.
And your view is that the delay is the prejudice.
The delay is the prejudice, and the delay is what makes her ruling appropriate for the other 11 topics that she was suddenly confronted with. If there are no other questions, I would rely on my brief. Thank you.
Thank you.
I'd like to just direct the court to page 350 of the appendix for the question of sort of what was the trial court's decision here, or what test was it applying. On 350 of the appendix, the court says, basically, I'm going to have pretty strong case law. I've been reading a number of cases. It's really totally in the discretion of the court, and goes on to say, and this is the part where I think the threshold test the court's applying is clear. The court says, on this identification testimony, it's really in the discretion of the court with respect to denying it when it is corroborated by other evidence in the case, and there is corroboration for the identification.
She says on the next page that I guess the other issue is, as I mentioned earlier, you really needed to raise this issue a while ago, and perhaps it might have been a different result. And she goes on to discuss the delay. So she is putting the delay on the table when she's discussing why she's reaching this conclusion, isn't she?
It's true. I mean, the court was complaining about this and clearly wished that defense counsel had presented this earlier.
Well, I'm not sure if she's just complaining. She says perhaps it might have been a different result.
That's true. I don't think anybody at the time understood this to be denying it as untimely, and I will say I believe opposing counsel, I think, just argued that the topics we're arguing about on appeal were denied as untimely. I've been litigating this case through the appellate division here, and that's the first suggestion of that I've heard. I don't think anybody until now had asserted that the application was denied as untimely.
But can't timeliness factor into this discretionary decision? And particularly where you come in with a list of 11 topics, which now have been narrowed for an appeals court to 3, and we can look at the law, and we can look at the FRI, and we can look at, but this is walking in on a judge with 11 topics, without briefing, without cases, without follow-up at this stage of the trial. So why isn't it within the trial court's discretion to say, that's a factor here? You got something else? Give me something else. But these 11 topics, no.
So I'll say trial courts have a difficult job. I certainly recognize that. And sometimes a trial court would be presented with a number of arguments, and some of them are meritless, and some of them have merit, and it's the trial court's job to sort through them and sort.
So let's say the trial court here had said, I looked at this and I just think, given you came in at this 11th hour, I'm giving you the one that you had given some notice of before. I'm denying all the others as untimely given the state of the trial now and my repeated requests in this late hour. Would that be okay?
I'm sorry, could you just?
They just went, the judge just went on timeliness and said, look, you've come in here, look at the stage of the trial we're at, look at this, which she does walk through, I believe. This is when you were asked, this is when it got here, this is when, and now you come in with 11 topics and you expect me to parse through them without any case law, I'm denying it. Is that okay?
On the one hand, it might be. On the other hand, I would point to this court's language in McCulloch and Lee saying that, it is appropriate for courts to decide these issues during trial. But I would just point back to the cardinal principle, as this court has said, that all relevant evidence is admissible unless
Whose
there's.
job is it to establish for the trial court so that the trial court will have the information to consider before rendering a decision as to the probative value and relevance of? Was that on the defense?
The probative value and relevance?
Yes, and the case law supporting that he was entitled to this, that he needed it. And I am puzzled how, in the calm of an appellate court, you have 3. You have 11. The trial court's responsible for the jury, for the lawyers, for staffing, and all these other issues. Are you suggesting to us that the trial court has to lay all of that out before they can say that the defendant is being denied if, quite frankly, you can see by the record when the request was made, how it was made, that the court did not abuse its discretion?
I guess just a couple of quick things. I know my light is on. I think it is on the proponent to establish the relevance and the probative value. I think that was clear on the record of this trial, the relevance and the probative value of at least
And the
these.
support
As for the legal.
as to his entitlement to it?
As for I don't think that counsel, by not offering case law has forfeited the issue. I would also point out the court was
So
aware.
the court's responsibility is to do the research, argue both sides as to the law, too?
I mean, the court's responsibility is to make the right decision when the motion has been presented to it, but I would point out that the court was aware that this particular expert normally testifies about cross-racial ID together with these two other
Are you
topics.
telling me proactively the court has to assume that those extra factors were going to be requested by the defendant when the defendant never even asked originally for cross-racial identification until the court inquired, hey, are you going to do something? Are you going to offer something? Because the court has to factor all of that into consideration with respect to the running of the trial.
Yes, again, I think once it was clear enough from the trial record that this was relevant and probative information. At that point, it was up to the trial court to apply the correct test. The trial court was aware.
It was up to the trial attorney to do their job and to get it to the court in a timely fashion and fully explore it so that the court could make that decision.
I'll just end by saying that the trial court was aware at the point where it made its final decision. There was reference to the fact that this expert generally testified about cross-racial ID together with weapon focus and stress effects. So, of course, the court could know from that alone that these topics had been approved by other courts, had passed the Frye test. There was nothing further that the court needed to know for at least those 2 topics that this should have been admissible evidence.
Thank you.
Thank you.